like to get things started. I want to welcome you to Schnepp's Media Smart Talk, where we're going to be discussing a very important conversation today, which is estate planning and advanced directives, brought to you by Joseph Klein of Korsinsky and Klein. So we're thrilled to welcome you, Joe, and I wanted to introduce you to everyone. I want to let you know a little bit about Joe. He's the founding partner of Korsinsky and Klein, and he manages the law firm's Elder Law Group, which includes handling all aspects of estate planning and long-term care planning. He has extensive experience with complex trusts and estates and regularly practices in the surrogates court in New York State. He's a graduate of Brooklyn Law School and is admitted to both the New York and New Jersey bars. In addition to being an attorney, Mr. Klein is also a certified public accountant in New York State. Joseph is an active member of the New York State bars and lectures throughout the state. He does pro bono legal work for nonprofit organizations and is also on the board of nonprofit organizations. Joseph enjoys spending time with his wife and 6 children, and he likes traveling and attending his children's activities. So we very much are thrilled to welcome Joseph Klein back with us to talk about estate planning and advanced directives. Such an important topic now, Joe.
Thank you. So I might want to change it to liked traveling and liked attending his children's activities.
Absolutely. Now the traveling is, what they say, like la backyard and the hacienda kitchen. So yes, I understand. That's fair enough to say. We all are going to have to look for some different hobbies to talk about that we enjoy. So, this is such an important topic. I think it's really sparked a lot of interest, even more so now. But the truth is, this topic really is a critical topic. It would be wonderful for you to share with us, what are some of the emergencies that people are dealing with today, because and what you see in your practice, because they don't have their wills and estates in order?
Okay, so first of all, our office workload has basically doubled since before COVID. We are a law firm of 10 attorneys, but we're still just very, very busy with, as you said, a lot of emergencies. So examples are people who don't have documents in place to dictate what happens if they're incapacitated. And also people don't have documents in place to dictate what happens if they pass away, what happens to their assets. So
what happens if
we have people who, so we have people who have been in hospitals for weeks on ventilators, and unfortunately, and if they don't have a power of attorney form, a healthcare proxy form, if they don't appoint agents who can handle things for them, then there's really nobody in place who can make decisions for them. So we have, unfortunately, many people in New York hospitals right now. Some of them have been transferred to nursing homes where family and friends are trying to file emergency guardianships to be able to take control of the individual, and which would basically, the court gives the agent power to either manage the person's business, make healthcare decisions for them, to be able to handle financial matters, access bank accounts, pay property taxes. There's a lot of important things people do in their lives, and unfortunately, a lot of these people did not prepare documents. And right now, because they're incapacitated on a ventilator, there's nobody in place who can handle things for them.
Wow.
And so that's going on right now. And
how are people dealing with that, with this, what's happening with the courts right now? So, on top of the fact that it's a very arduous thing for someone who's not used to going to court every day to have to deal with that, particularly now, are there special circumstances that allow people to even go to courts now and deal with this?
So really, nobody's actually showing up to court. The court has certain people working from home that are accepting emergency cases. So actually, there are some cases where people do have to show up in real emergencies, but most of these cases are being done from home, where the attorneys file papers and send it in electronically. and the court's trying its best to deal with many emergencies. They're very, very busy too. So, they have emergencies in different categories of emergencies. And now certain papers have to be signed in order to do a guardianship. Now, New York has an emergency law that allows people to notarize things and witness things via video conferencing, whether it's FaceTime or Zoom. So a lot of the clients or people that need to get things signed can sign it in front of a notary or an attorney via Zoom, and then they don't actually have to leave their house. So New York has ways to get these things to happen. It's just much harder now because it really has to be a real emergency. So anything that's not an emergency is really not getting done. So that's one type of emergency that we're dealing with right now, is people who are alive but unfortunately incapacitated. The other type of emergencies are people who unfortunately passed away. There's thousands and thousands of people in New York City that passed away recently, and we have a lot of those estates, people who owned companies, small businesses, people, accountants who had practices, and it's really a mess because the family can't access the assets, can't access bank accounts, because a lot of these people did not plan in advance and did not give clear direction as to who's going to be in charge of their estate. So, when a lot of these people said, well, I'll do it tomorrow, next week, why don't I spend money, instead of paying the attorney, I'll just go on vacation this year, and maybe next year I'll spend my extra money on legal documents. And unfortunately, a lot of people weren't expecting to pass away. People in their 60s, low 70s, a lot of these people are very young for passing away, and it has left a big mess, especially people who are on second or third marriages, people that have complicated families. And right now, they did not leave any direction as to where the assets should go, who should be in charge of the assets. And there's a lot of fighting going on between a lot of family members. And the longer these fights go on, the quicker the value of mom or dad's assets are going down in value, because bills aren't getting paid, their customers aren't being attended to. So that is a big problem. Now, we are trying to file as many emergency estates as possible. We're filing papers. The surrogates court is open for emergency estates, but again, what they define as emergency, is a little complicated. And even the real emergencies, they're very backlogged right now because a lot of people are working from home. A lot of people that work there have, families at home that are doing schoolwork. So the court system is not really working efficient right now. So these are people who unfortunately did not get their affairs in order in advance.
And that's, what's stress? At any point in time, dealing with the sadness of losing a family member and then having to deal with all of this at your time of, real difficulty must be tremendously difficult. So, to think about your family and what will be left of all of this and how your family will handle it, you can really take care of that all ahead of time and at least have them have some peace of mind with that.
Correct.
So what do I need to be concerned about? If I decide I understand this is really important, I need to take care of this, what do I need to think about? What do I need to do?
Okay, so when somebody thinks about estate planning, which really that's what this is I guess there's three basic categories of estate planning. So the most important category typically is succession planning, which is setting up assets in case, God forbid, you pass away. As I mentioned before, not to leave a mess, to give clear direction as to who will inherit things, and also clear directions as to who will manage your assets the next day after death. And also not only to have documents in place, but also to give directions, to give instructions, burial directions. Somebody in their mid-60s might not have even thought about it. And then if something happens to them, nobody has any idea where they want to go, what to do. There are a lot of options out there. So it's, especially as this COVID thing, nobody really knows what direction it's going to take. Will it come back in the fall? Will it change, and all of a sudden hurt people in another way? It's really pretty scary. I don't mean to scare people. However, nobody really knows what's going to happen, so succession planning is important. Second category of estate planning is long-term care planning. That's not an emergency right now, but I'm going to talk about that. People are concerned, what if I'm 95? I need a home health aide. I need a nursing home. I don't want to have to use up all my money and pay for expensive health care. New York gives the best Medicaid coverage in the United States. So we could discuss that just to talk about how that works. And the third category is estate tax planning. It's people who have assets more than approximately $6 million, which a lot of people in Manhattan, their apartments might be worth more than, $2-3 million, just like that, or in other places in New York City. So if somebody has assets more than $6 million, there could be an estate tax when they pass away that their family members will have to pay within 9 months after death. There are a lot of planning strategies, so it's important to just look out for it for the wealthy crowd. Obviously, most people are not in the wealthy crowd. However, if there are people, that's definitely something to look out for.
Okay.
So succession planning really is the number one focus with regard to an emergency. Long-term care planning is about saving money. Estate tax planning is about saving money. Succession planning is not leaving a disaster or a mess.
Right. So that's really a critical for everybody.
Right. So I could start discussing that.
Yeah, let us know, but tell us what that is, what entails in that, and what it would cover, and how it can be so helpful.
Okay, so succession planning, the basic description is giving directions as to what happens if you pass away. Now, there's 3 ways to give directions. So number one, you could leave beneficiaries on accounts, bank accounts. So for people who don't have a lot of assets, for people who don't have real estate, for people who have bank accounts and retirement accounts and they rent apartments, then if you leave beneficiaries on your accounts, then when you pass away, the bank will give the money, the investment bank or retail bank will give the assets to whoever you listed as beneficiary. It's really simple to do. You call the bank and you put beneficiaries on. A lot of people, come into our office and they have had beneficiaries from 30 years ago, maybe from a husband that passed away, or an ex-husband from, that they haven't spoken to in a long time, or nieces or sisters or parents that have passed away. It's important to make sure that's updated. Mm-hmm. Sometimes you think you might have filled out a beneficiary form when you open up the account, but for some reason, it just never happened. So make sure your accounts have beneficiaries. Also, a lot of people don't realize that checking accounts can have beneficiaries. So the account that your Social Security goes into can have a beneficiary. Some people just don't put them on. They don't have anybody on the account. And then when they pass away, there's no direction on the account. The other way is to have a will. And the third way is to have a trust. So a will is a document where you can give detail. You give detail who will manage the estate if you pass away, who will step in the next day. In case of an emergency, whoever you appoint as executor can really step in the next day and control your assets to make sure that, like, if you have rental properties, everything is taken care of. And the job of the executor is to collect your assets, manage them quickly, and give them out. And the will also dictate, if you don't have beneficiaries on accounts, who will inherit these assets. Now, sometimes it's easy. Somebody has 3 kids, all right, 3 equal shares, no problem. But sometimes life is a little more complicated and it's not 3 equal shares, and people don't have children. They want to leave it to charities or to friends and families. And what if you leave it to a friend and the friend passed away? So you need a backup to the friend. Or if the friend passed away, do you want it to go to the children of the friend or only if the friend is living? You might not even know the children of the friend. There's a lot of detail. You might have a rental property that you have a divorced daughter living in, and she's been living there for free for many years. So do you want the house to be sold immediately and the daughter just has to move somewhere else? Or do you want to let her live in the house for 2 years without paying rent while she finds a new place? There's a lot of direction that might have to go into certain assets. What about, again, if you own a business? So who's going to take over the next day? Who's going to get the business? What if you have 3 kids and one child works in the business and the other 2 children don't work in the business? So what are you going to do? So it's important that to have direction, for specific assets that might need more details than strictly, how to divide it. So the next issue also is, what if you have a child who's disabled? What if you're giving assets to a niece and she's disabled? So you might not want you might want the niece to get the asset, but not to throw her off disability. What if she's on government programs? What if you want to leave it to your mother, but let's say she's on Medicaid? So you can leave assets to trust for people instead of giving it to them directly. So what is a trust? A trust is like a non-human owner of assets. It's like you set up a robot and you put the assets into it, and it could be used for this niece that's disabled, for the aunt or mom that's on Medicaid, or if you have little children, you don't necessarily want a 15-year-old to have all this money. That when the child's 18, he can go out and buy himself a Lamborghini and or spend the money in Las Vegas. So there are many complicated ways to leave assets to children or family members which would make sure that the money is well protected.
So you can name minors as beneficiaries, but you want to think through what happens when they're left that money. Is that
yes?
Correct?
So you don't leave it directly to a minor, you leave it to a trust for a minor. So
they can't be a beneficiary, for example, on a bank account, or can they? Can a minor?
You could leave them as beneficiary. However, if they're a child, then maybe a surviving parent would have to manage it for them. So you could leave it to minors. If they are a minor, it's better if you leave it through a will where you have more detailed direction. You're saying, I want the $500,000 to be for my son Charlie, but I don't want it to go to him directly. I want it to go to a trust for him that my brother will manage until Charlie's 25 or 30.
Mm-hmm.
So with documents, with wills of trust, you can give more direction or more detail so that the money you worked so hard for is protected. So you not only leave them the money, you leave it to them in a protected way. And that's important, in a way so that your child won't spend it in a week, in a way that if your child has creditors, if your child has marriage problems down the road, then your child's inheritance will be protected from bad people coming after your child. So that's a benefit.
This is why it's so important to really talk with someone like yourself, because you think, okay, I've got my beneficiaries and I'm having my child as my beneficiary and I'm making these decisions, but you're not thinking about the potential consequences as deeply as you do. And that's an important piece in dealing with the succession, isn't it? To be able to
Yes.
think 10 steps ahead.
Absolutely. Now, in our firm, we're very honest people. If somebody comes in and has zero drama in his life, maybe beneficiaries are fine and there's no problem. So it really depends. So not everybody needs complex documents. However, I think everybody should evaluate if they do need it. Maybe they don't. Hopefully they don't, and everything's fine, and nobody's disabled and all that. Hopefully when your children inherit, they're not 15. Hopefully they're 75 at that point. But so it's always good to evaluate. So you might not need anything. Maybe everything is fine. And maybe beneficiaries are fine. But evaluating is what's important. When people come to our office, we grill them. We ask them a million questions about their life. We ask them about the family, and then they might say, well, I don't need anything. But after we ask them so many questions, they start realizing, hey, maybe I might need something a little more complicated.
Yeah, I don't think there are many families that have zero drama, but so I mean, you never really think about it until you're asked that. What about if you're leaving, you want to name someone who doesn't live in this country? Like, for example, if your parents are foreign citizens, can you leave them as beneficiaries on your property or on your bank accounts? And, is it hard for them to collect assets if they're in another country?
Okay, so, in modern day 2020, it's gotten a lot easier. So certainly you could leave anybody in the world assets. It's just when people leave beneficiaries like that, we make sure they give us, for a file, very clear contact information, phone numbers, addresses, email addresses. So we really, have to be able to find them. Now, if it's very easy, if that beneficiary sends us a copy of a driver's license from wherever they are, it's definitely easier that way.
Mm-hmm.
However, even if not, then certainly you could leave assets to anybody anywhere.
So you could give them specific directions on what it is you need to provide to make sure that that's a smooth transition.
Right. We just have to make sure we find the right people, because we sometimes get wills from other attorneys that leave a name of my cousin in another country, and it's a very common name. And how on earth are we supposed to find them?
Wow.
And so it's better to give very clear directions. And when somebody comes to us, we certainly, that's ask them for it. That's why having ID in the file is a good way to go.
Terrific. That's great advice. What else do we need to know about succession planning?
Okay, so another option is, instead of people creating a will, they create a trust. Now, one benefit to putting assets into a trust is to avoid probate. So if somebody has assets, they pass away, the family has to take the will and file it in the local court, in surrogate's court. So typically, an attorney does that. Attorney has to get paid for it. It could take a couple of months. So for most people, it's not the end of the world. They could wait a few months, and the attorney's fees aren't so high. However, some people say, if I can avoid my family having to go through a court process, then I would rather transfer my assets while I'm alive to this trust, this non-human owner of assets. I put into a trust while I'm alive. Therefore, when I pass away, then there's no need for a court system to be involved. In other words, if all my assets have beneficiaries attached to them, so I have assets in trust, the trust document dictates where the assets go. Bank accounts, the beneficiaries dictate where those assets go. Then when I pass away, there's no need for a court to be involved, because all the assets already have built-in directions where they're going to go. Sorry about that.
You got to move around with that light. You got to move around.
Okay, yeah. So basically, if there's direction in the documents, then that helps. Now, New York probate is really not a big deal. This is more important. So when would somebody say, I want to avoid probate? So number one, if somebody's worried about lawsuits, then transferring assets to trust while you're alive would avoid having a probate estate. So let's say somebody has a creditor, somebody's after him for money. Mm-hmm. So when the will gets probated, a creditor can file a claim against an estate. Let's say you had a dispute with a nursing home. The nursing home could file a claim against the estate. If there is no probate estate, if there's no file in the court transferring assets to the next generation, if all the assets are in trust or passing to people outside of the court system, then the creditors can't sue. So if people are worried about creditors, then giving assets away, you're essentially giving it away while you're alive. I don't have anything. So John Doe passed away. He didn't have anything because his assets were given away, and his bank accounts had beneficiaries. It goes to them directly. There's no court system. Also, other states have complicated probate. So let's say somebody lives in New York, has a condo in Florida, Miami. and has a small townhouse in the Berkshires of Massachusetts. So then when they pass away, the children have to hire a probate attorney in Florida. They have to hire a probate attorney in Massachusetts, and it becomes a real pain in the neck. Florida probate has court appearances. So it's a lot more expensive there. So a lot of people in the New York area have Florida condos. So if somebody has a Florida condo, then I would recommend avoiding probate.
So that means you'd want to put all of that in a trust.
Yes. So people take the real estate, put it into trusts. Now, people ask, well, what type of a trust? There's revocable trust, there's irrevocable trust. So what are you talking about? So if the only concern is to avoid probate, which is avoid the court system being involved when you pass away to get the assets to go to the next generation, then it can be a revocable trust where mom could control her own assets until she passes away. Mom could put her assets into a trust. She could control it herself with nobody else. And then she controls it, and she could change a trust whenever she wants. It's revocable. So that's when you want to set up a trust to avoid probate and avoid those creditors when you pass away, if that's the only reason. If the reason to set up the trust is to do long-term care planning, Medicaid planning, which we'll talk about briefly, or to do estate tax planning, then that trust has to be irrevocable, where mom cannot control the trust, and she has to appoint other people to control the assets for her. And so that's a different story. So revocable.
They can help her before she passes with that money for long-term care.
Yeah.
Okay.
So I'll just talk about that briefly. But before I do, I just want to add into succession planning. Typically, along with succession planning comes a power of attorney and a healthcare proxy. These are important documents. It's usually a package of documents. You do a will or a trust. Power of attorney, healthcare proxy, as I mentioned before about what happens in the case of emergency, is if you're concerned that if you're incapacitated, or if you're just 95 and not in the mood to handle things for yourself, if you could appoint documents where agents can handle these things for you. It'll avoid the need for a guardianship. It'll allow your agent, a power of attorney, can handle your retirement accounts, can handle Medicare issues, Medicaid issues, Social Security, anything you might be dealing with in your life, an agent and a power of attorney can handle for you. So it's a very important document to have. Lawyers typically do it as a package with a will. Healthcare proxy, who makes healthcare decisions for you. A lot of people have different views about, if they're in a coma, end of life issues. So end of life issues are important. Some people say, well, let me just appoint my daughter. My daughter can decide. I trust her. I don't have to give her any extra direction. I trust her judgment. That's fine. But if somebody doesn't have a daughter and is relying on friends who might not know what she really wants, you could put that in a document. So end of life planning, end of life decisions are important. That can go into a healthcare proxy. Very important to get done.
So these are documents that are necessary when to protect you while you're alive.
While you're alive.
Unable to make or not wanting to have to make all those decisions and manage all that on your own.
Correct. Exactly. Okay. Yeah. Okay. So long-term care planning, I don't want to go too much into it, but basically if somebody doesn't wants to protect their money so they can have Medicaid pay for long-term care, which is home health aides or nursing home care, New York allows you to take your assets and give them away to a trust or to children directly and qualify for Medicaid. Now, to have Medicaid pay for long-term care. If somebody needs a nursing home, these assets have to be transferred 5 years in advance before Medicaid nursing home is needed. Now, this is just a quick summary. There are various exceptions to rules. You could give assets to a spouse without a 5-year look back, but basically this planning should be done 5 years prior to when you need the nursing home. Because nobody knows when that might be. So people ask, when should I start worrying about this? Most people start worrying about this in their high 60s, low 70s. People have a neighbor who had a stroke. People have a relative who got sick. That's when people start worrying about this. So again, transferring assets. If somebody wants New York Medicaid to pay for nursing home care, it has to be done 5 years in advance. Now, currently, for home care in New York, you could transfer away all your assets and have Medicaid pay for home health care aid almost immediately. This is the only state in the United States that has no waiting period for home care. However, this is very recently, over the past month, the law has changed, and beginning October 1st, there will be a 2.5-year waiting period until you can apply for Medicaid. So people who do want to protect their assets in case they need home care, so now's the time to gift away your assets. I'll talk about how to do that in a minute. Now's the time to gift away your assets and apply for community Medicaid, which is Medicaid at home. Because if you wait until after October 1st, you're going to have gifted your assets 2.5 years prior to the application. So there really is a unique opportunity now before October 1st to gift assets away.
So it's something if you're thinking about, it's really something that you shouldn't wait on at this point because the law is going to change shortly.
Exactly. And so everything has to be done before October 1st. Now, there's 2 ways to gift assets. You can gift it to children directly. You can gift it to a trust. A lot of people don't want to gift assets to the children because what if the child has a problem in her life, financial problems, marriage problems, health issues. There's a lot of children don't want to pay income taxes on their own tax returns. So transferring it to a trust is more popular. In New York, retirement accounts are exempt. So you don't have to give away your retirement account. So in order to qualify, there's an asset test and an income test. The asset test is basically the applicant, let's say mom can't have more than $15,000 of assets in her name. So everything over $15,000 has to be transferred. Retirement account is an exempt asset. Now, technically your house is exempt, your primary residence is exempt, but most people gift it away anyway because they don't want the house to be subject to creditors and part of their estate when they pass away. They don't want, there are certain ways Medicaid can put liens on houses. So again, most people take their house, their assets, other than retirement accounts, they gift it away to a trust. And this trust, unlike the other trust we spoke about for avoiding probate, this trust has to be irrevocable, and mom cannot be the trustee. So it typically only works when mom has people that she trusts very closely, whether it's children or some people have no children. It might be friends, neighbors, nieces or nephews. You really have to give it away. Now, the way the trust operates is a little complicated, and the way it's really a custom crafted situation as to how exactly it's set up, because trust could be set up where mom gets income from the trust. Some people have pensions and large social securities. Some moms don't need income from the trust because they're living off their pension, social security, and retirement accounts. So the more income in a trust that you allow mom to have, the more income or assets are technically exposed. So how much income mom is allowed to get from the trust depends on what her other income is. So we really sit down, look at a master spreadsheet of what income does mom have, what assets does mom have, and we set up a way where mom could protect her assets, but mom shouldn't feel like she has to call her daughter every time she wants to buy a sandwich. So a lot of moms don't want to be too tight, don't want to feel too tight with money, but they want to protect their assets. So there's a balance between, not every mom gifts away everything. A lot of moms say, you know what, I want to protect most of my assets, but I don't need to protect every penny. You know, I want to have enough money in my name so I feel comfortable. And however, you know, I want to protect most of my assets. So it really depends on the person. It really depends on the relationship between mom and the trustees. If there's a totally trusting relationship, then a lot of moms are easier to just give control. A lot of moms who are 95 say, you know what, I'm happy to not be in control anyway. So, no problem. So
a lot to think about, and that's really what you do with people, is to be able to sit down and look at their circumstances in particular and help them make the best decisions for them.
exactly. However, this is something that's definitely very popular. It's long-term care insurance is great, but a lot of people don't have it. So if somebody has long-term care insurance that covers all this long-term care needs, then you don't need this Medicaid planning. But some people have policies from 25 years ago that do not have an inflation rider, and therefore they cover very little. So a lot of people who think they may have long-term care insurance, they might have bought a policy from somebody that wasn't giving them all the information, and they find out now, 20, 30 years later, that the policy doesn't cover much. So even for people who do have long-term care insurance policies, make sure you understand it. Don't rely on a document that's in your drawer that you haven't looked at for 30 years. Make sure that it covers what you think it covers. And if it doesn't cover, have a plan. If you want to pay out of pocket, no problem. That's your plan. If you don't want to pay out of pocket and you want Medicaid to pay, well, you need to transfer assets. You can't wait for the last minute.
Great. I know you wanted to touch upon for the wealthy estate tax planning.
Yeah. So estate tax planning, basically, if people have assets over $6 million and they're concerned if they pass away, that there will be New York State estate tax. In a couple of years, it's going to be federal estate tax also, because right now the federal government allows you to pass away with $11 million without estate tax, but in 2025, that's bouncing back automatically to $6 million. So if you are worried that mom's assets might be over $6 million, mom could gift assets away while she's alive. She can gift it to a trust. She can gift it to children. There are complicated ways, how to do things if the assets are complicated. However, talk to somebody. Don't ignore it. Because if mom passes away, the assets are more, there's a lot of tax. And you could have easily given things away. You could have worked this out. And most people who have a couple of million over the million you're allowed to have can gift it away without a problem. Obviously, the Warren Buffetts, Donald Trumps, who have billions of dollars, it's harder for them to gift assets away and avoid estate tax. But people who have a lot less money, but might still be over the 6 million, can give it away. So it's definitely important to talk to a lawyer about it and just to see what can you do to avoid the estate taxes.
Great. What would be helpful? Would you mind kind of just quickly reviewing for the succession planning and the advanced directives, what are the specific documents that we should be thinking about that are critical?
Okay, so just to review specific documents that you might have heard about, people talk about power of attorney. That is where mom appoints an agent who can handle her financial matters in case she's either incapacitated or just unable to handle her affairs. Now, power of attorney, you can appoint multiple agents on it. So it doesn't have to be one child. It could be two. You can have it where each child can act independently. Next document is healthcare proxy or living will. So those two go together. Healthcare proxy is where you appoint an agent who can make healthcare decisions for you. New York allows you to only do one at a time. You can't have 3 children working together. So you have to appoint a person who can handle it for you. Now, anytime you appoint agents to handle things for you, it's always good to have a backup, because agents can pass away, agents can't become incapacitated or move out of town. It's important to have a backup. So healthcare proxy is where you appoint an agent who can handle things for you. Now, living will is where you give direction as to what the agent has to do. So you say, well, I'm appointing my daughter. However, I don't want to allow my daughter to handle things herself. I want to give direction. If I'm in a coma for 6 months, if I'm brain dead, if I have cancer, whatever it is, you give direction as to what the hospital should do if you don't want your agent to have the full power to control things for you. This is more popular when your agent isn't really so close to you. or you don't feel your agent's going to have the guts to do what you want her to do. Will is if you want to describe where assets should go and you're not worried about avoiding probate, the assets will go through the court system, which I mentioned, New York, not the biggest deal. And then there's a revocable trust. That's a trust document. Again, I mentioned that trust is like this robot you create. It's not owned by mom. It's not owned by the children. It owns itself. And whatever rules mom programs into the trust, those are the rules of the trust. It's a man-made document. So for people who have complicated things, you could set it up any way you want. Revocable trust only helps to avoid probate and avoid creditors when mom dies. The advantage is that mom could control it, which is important for a lot of moms or for people who aren't moms. Now, irrevocable trust is another document. It's also a trust which avoids probate and avoids creditors. However, that has extra power where mom has no control over it. She can't touch it. So that has benefits when mom is trying to apply for long-term care and wants the trust to be a Medicaid qualifying trust. Medicaid wants to see, did mom really gift it away? If mom gifts her assets to a trust that she controls, Medicaid says, take it from the trust. What do you want from us? So if the trust has to be rock solid, where mom says, I wish I could take it from a trust, but I can't. I have no access to it. Then the trust has to be irrevocable. Also, irrevocable trust, if somebody's doing estate tax planning and wants the assets to not be subject to estate tax when mom dies, mom has to give it to an irrevocable trust. She again has to give it away and have no control over it.
Wonderful. Thank you for that review. That's helpful. Can you put a trust? Can you put in a trust a house that still has a mortgage on it? Do you have to own it free and clear to be a trust?
So the answer is, if somebody has a house with a mortgage and they gift it to a trust, what happens? So when you sign a mortgage document, you're signing that if you gift the house away, the bank has the power to cancel the mortgage. They have the power to cancel the mortgage. It's not illegal to do it. You're just technically breaching the contract with the bank. So the bank still has a lien on the property, and whoever signed the mortgage documents is still responsible. However, the bank has the power to call the mortgage. Now, most attorneys in our firm and other attorneys who do these trusts, like I could tell you, I've never seen a bank call a mortgage, cancel a mortgage, because they're in the business of giving mortgages, and as long as the person pays, why should they cancel the mortgage? They're getting their interest and they don't have a problem with it. So the practical answer is that they practically don't cancel the mortgages. However, they could. So if somebody has a mortgage that is so important that they can't ever refinance it, if the worst case scenario is that one of the kids would have to refinance the mortgage, then it's worth taking the chance. However, if somebody has $1 million mortgage on a $800,000 house, then you might not want to take the chance. So it really depends. But again, most people transfer with mortgages and the banks are okay with it.
Okay, great. I mean, there's so much to ask, and there's so many unique circumstances. As many as there are people, there are unique circumstances. So Joseph has been wonderful to offer anyone who's on this call a free consultation, obviously over the phone, but that's valued at $400. And it's a nice opportunity I thank you for that, Joe, providing that to our participants. But it's a great way to kind of jumpstart yourself in delving into such an important thing to protect yourself and your family. I want to ask you one more question since we have you, get your special advice. What special advice are you giving your family and friends right now?
Well, one piece of free advice, I would say that's important for people is to give direction to them as to what your assets are and keep a special place in your house, whether it's a drawer, whether it's a folder of what's going on in your life. For example, we have people that are passing away now where a lot of their bank statements are online. Their whole life is in their email. And if your family doesn't know what your email addresses are, they can't access it. And it's a mess. So have a drawer in your house so you don't have to, so your family won't have to start looking for the mail, trying to figure out what assets you have, if you owe anybody money, any disputes you may have had with people that need to be resolved. You know, there's a lot of private things people have in their life, and when they pass away, it becomes a real mess for the family members. So I would say, you know, keep a list in a drawer. Nobody even has to see it, but just every year or so update it. So if you pass away, your family will have a much easier time dealing with your estate. So that they should be able to access your email addresses, your bank account information. You know, if you have a life insurance policy, if you don't tell your family about it, then it's a big problem. You know, retirement account information, your broker's information, your broker's phone number, burial information, very, very important. I mentioned before, you might have a plot, and if nobody knows about it, then you're not going to be buried there. So, you know, a lot of people pay money for a prepaid burial plan just so that nobody has to lay out the cash when you pass away, you know, very quickly. But people have to know where the burial plan is or what you sign up for. So keep a folder, keep a drawer in your house where everything is. Make sure your family knows where it is. You know, passwords, you don't want to email all your kids, you know, expose the information, but you keep it in a closed envelope. And, you know, as your password change, you can update it from time to time. So that's something that even if you don't do a will, and even if you don't do any documents, that would definitely be one step in the right direction to help out your family and friends so they can deal with your affairs very easily. And it's even more important if somebody has a business that's, you know, if nobody knows what's going on, you know, who the vendors are, it's an absolute mess if you have your own personal business. I just want to add, by the way, we have offices in Manhattan and in Brooklyn. Our main office is One Penn Plaza. Right now, nobody's going anywhere, but hopefully soon. We have every train under us, people coming from Queens, the Bronx, all over the place, Long Island, and our other offices in Brooklyn, and we hold meetings in both offices, and we're happy to help anybody that needs assistance.
That's wonderful. Their website is kklawfirm.com, so you can visit them there as well. And I did share your email address too, so people can reach out. I do have, before we finish up, I do have one question here. If I put a trust in a place, should I let my family know ahead of time? And how does it work? God forbid something happens to me. You know, that advice that you gave about, you know, yeah, directing everybody is such simple, but critical.
Okay, so that is a good question. Now, some people set up trusts with the ability to change things. So let's say somebody sets up a trust where they're leaving somebody out. They're in a fight with somebody and they're leaving somebody out. Now, if you give all your family members this trust and you give copies to everybody, and then you change your mind, you reconcile, then everyone's going to know that at a certain point you left out, you know, your child, you know. So, and even if you change it later on, there'll be a history of changes. So some people that have more complicated documents, they're giving charities this amount of money and different people this amount of money, you know, and if you might change it, a lot of people say, I don't want everybody seeing it. I only want everybody seeing my final draft, you know, the final version. So some people who are concerned about that, they tell their family who the attorney is or who the law firm is, but they don't give out the document to everybody. So in the drawer at home, they say, I have a trust. Maybe they leave the front page and they say, this is a law firm. They have a copy. Or they say, I have a copy in my safe deposit box, or they have it saved. So again, if somebody thinks they might want to change it and you know, having a bad history is, you know, might cause problems later on, then I would say don't, you know, give it out. But if something's more straightforward and it's equal shares and all of that, then yes, you know, email the trust to your relatives, because if you name a trustee or an agent on a power of attorney or an agent on a healthcare proxy, but they don't know that you appointed them, then whatever you want to happen is not going to happen because they're not going to know that you appointed them. So either give them the documents and tell them, yeah, you're appointed. If something happens to me, it's all ready to go. And the other option, as I mentioned, if you feel you might want to change it and you don't want everybody knowing your changes, then you just give the name of the attorney and then you tell them to call the attorney or the law firm in case of emergency when the documents are needed.
So this is a really important piece to have a part of your easy to get documents that you can leave for people to be able to address.
Correct.
Really important. I have, I think, one more question, if you don't mind.
Sure.
What is the range that it could cost to set up an irrevocable trust?
Okay, so generally about prices. So a package of, let's say, a will, power of attorney, healthcare proxy, including, hours of meetings and advice, that's usually around $3,000. Setting up an irrevocable trust, if it's added on to that, that's usually another $1,000. So let's say that package is around $4,000. So that's the range of what it is. It obviously depends on of the circumstances, how much time is involved. If it's a more complicated situation, it might be more. And also, when somebody sets up a trust, often assets have to be transferred to the trust. So it's not only setting up the trust. If it's real estate, often there are deed transfers. Properties have to be transferred to the trust. People might have ownerships in LLCs and in companies and corporations. Those have to be transferred in. So we typically try to work out one flat fee, one package, just so the client feels comfortable that there's no surprise expenses. So, but again, like a package of a trust with a will and a deed transfer, that's typically $5,000. Will, power of attorney, healthcare proxy is $3,000, and there's different prices in between. So that's why it's important to have a consultation, because it's when you have a no pressure consultation, then we discuss what you need. We discuss issues that relate to you, options, how to deal with them. Often there's no clear answer. There's option A, B, or C. The client goes home and thinks about it, potential client, and then comes back, if he or she wants to do something. So the first step is just to educate yourself on what you might need. You have to take your specific fact pattern, your personal story, and talk to a lawyer, review it, just so you see what exactly you need. This is often not something that you could just print out from staples.com or any other, these types of websites. Often you need a consultation. You need to talk to a lawyer about it, and then the documents come later.
No, it's a very important point. I mean, I think that's something that really was shouting out at me throughout this whole discussion was, how important it is to be specific about your situation, and that's what you can really do, that no online document is going to be able to do, and be able to make sure you're thinking 10 steps ahead in something that's a difficult thing, quite honestly, to think about. So having someone who's knowledgeable and compassionate, and honest, who can walk you through all of that. And, you really showed us that it's very doable, and it's not something that people should be putting off or be afraid of. And, you offered very generously for people to even set up a no pressure consultation with you. And I hope that everyone takes advantage of that and at least gets this started to protect themselves and their family. So thank you so very much.
No problem.
Klein,
thank you.
Korsinsky and Klein. What a wonderful conversation, and look forward to having you educate our attendees in the future, and wishing you a wonderful day. Everyone, please stay safe. Thank you so much for joining us, and we'll look forward to seeing you at our next webinar.
Okay.
Bye-bye.